whether the Consumer Fora is a court or not, and whether non-advocate can practice in Consumer Fora or not. These are two important questions which are required to be answered. Today, we are going to answer all these questions, and we will discuss on this with Supreme Court case laws. Welcome back to my channel, Courtroom Battles. Dear friends, my name is Dr. TUSHAR MANDLEKAR and I have been practicing in Bombay High Court since last 15 years. This is the channel specifically open for the benefit of the young lawyers in this country, and I am thankful to all of you for joining my channel. Consumer Protection Act 1986 came into effect and consumers in country received some authorized fora to raise their grievances. Now, we all know that it's a three-tier system where district consumer forum is available in every district. State consumer forum is also available in all states. And there is a National Consumer Commission which is at New Delhi. But dear friends, the important question came into picture whether consumer forums, which are quasi-judicial bodies, are courts or not. In a landmark judgment, Laxmi Engineering Works versus PhD Industrial Institute, Honorable Supreme Court has held that consumer forums are quasi-judicial authorities, but they are not courts. 1995 3 SCC 583, Honorable Supreme Court has held that the review of the provisions of the Act discloses that the quasi-judicial authorities and agencies created by the Act, known as district forums and state commissions and the national commissions, are not the courts, though invested with some of the powers of the civil court. They are quasi-judicial tribunals brought into existence to render inexpensive and speedy remedies to the consumers. It is equally clear that these forums or commissions were not supposed to supplant but supplement the existing judicial system. The idea was to provide an additional forum providing inexpensive and speedy resolution of disputes arising between the consumers and supply of goods or service providers. The forum so created is inhibited by the requirement of the court fee or the formal procedures of the court. Consumer himself can go and file his complaint, and it is not necessary that he should be filing the complaint through advocates only. Where a large number of consumers have similar complaint, one or more consumers can file a complaint on behalf of all. This complaint is called as a complaint filed in representative capacity. The idea was to help the consumers to get justice and fair treatment in the matters of goods and services. The entire Consumer Act revolves around the consumer, and the grievances raised by the consumers are required to be redressed. So dear friends, it is quite clear that consumer forums are quasi-judicial authorities and they are not courts. So the powers of contempt of court are not available to the consumer forums. But there is an inbuilt provision under section 25 and 27 of the Consumer Protection Act 1986 by which the awards or the decrees passed by the forums can be executed by the consumer. And there is also a power of a criminal court empowered to the consumer forums by which jail can be given to the service providers or the judgment debtors. Dear friends, there is a very interesting case law in this country by which the Honorable Supreme Court held that non-advocates can come forward and fight for the consumers. 2011-9 SCC 707 C. Venkatachalam versus Ajit Kumar and Bar Council of India versus Sanjeev Kumar. Dear friends, consumer complaints were filed in Mumbai District Consumer Forum in 1997 and 2000, and agents started appearing for the consumers. The Consumer Forum held that the agents have no right to appear before them. The finding was, since the agent is not a registered advocate, he cannot practice in Consumer Fora. The interim orders passed by the State Commission were challenged before the Bombay High Court and petitions were filed. The petitions were allowed by the division bench, and the High Court held that the Consumer Fora constituted under the Consumer Protection Act 1986 have trappings of the civil code but are not civil courts within the meaning of the provisions of the civil code. And the Honorable Bombay High Court held that the consumers cannot be compelled to get the services of the advocates in consumer complaints. The Honorable High Court held that the right of the consumer to appear before the fora individually or through authorized representative is a fundamental right to get the justice, and they cannot be compelled to have advocates for their arguments. The Honorable High Court held that such a right is also not inconsistent with the Consumer Protection Act 1986 read with Advocates Act 1961. The Honorable High Court has also held that there are various other acts like Income Tax Act, Sale Tax Act, wherein agents are allowed to represent the assessee. Dear friends, the matter went up to the Supreme Court and the larger bench was constituted, and the Honorable Supreme Court decided the issue. The basic question before the Honorable Supreme Court was whether the agent can represent large number of consumers in consumer forums, by which the Advocates Act 1961 is defeated. It was argued that as per section 29, ordinarily the right to practice in the court is available only to an advocate who is a qualified advocate having the degree in law. Section 29 of the Advocates Act 1961 says that advocates are to be recognized by the Bar Council. Section 32 of the Advocates Act 1961 deals with the power of the court to permit the advocate to appear in the court for his client. Section 33 of the Advocates Act 1961 says that no person shall, on or after appointed day, be entitled to practice in any court or before any authority unless he is enrolled as an advocate. The Honorable Supreme Court has clearly held that the right of the consumer to appear before the consumer fora without an advocate is also a fundamental right. Consumer Protection Act 1986 is one of the benevolent social legislations intended to protect the large body of consumers from exploitation and extortion. The Act has come as a pinnacle for consumers all over the country and is considered as one of the most important legislations enacted for the benefit of the consumers in independent India. The Consumer Protection Act 1986 provides inexpensive and prompt remedy. Every person has a right to work and make an honest living. Every individual has the right and freedom to do anything so long as it does not violate any law. Thus, a retired or even an unemployed doctor, engineer, scientist, teacher, or any other person has the right to offer his services as an agent. In other words, an individual has the right to choose acting as agent as his profession. Article 19(1)(g) of the Constitution guarantees that freedom. The mandate of Article 21 is fulfilled. In doing so, he does not practice the profession of the law or violate the provisions of the Advocates Act 1961. He only invokes the freedom guaranteed under the Constitution of India. An agent merely helps his client or consumer to effectively represent in consumer fora. He also can seek some financial assistance or the fees. Dear friends, according to the Supreme Court judgment, agents are allowed to practice in consumer fora. In order to govern the conduct of the agents, the regulations were framed under Section 30 A of the Consumer Protection Act 1986 by the Honorable National Consumer Commission, New Delhi in 2014, the regulations permitted an agent, representative or non-advocate to represent the consumer in consumer forums. These three categories were specifically created by the Honorable National Commission into regulations. According to the Regulation 3, a party or the consumer may appoint his agent or representative to represent him in the consumer forums. The consumer can appoint such a person subject to the condition that the person is appearing on an individual case basis. 2. A person has pre-existing relationship with the complainant, such as relative, neighbor, business associate or personal friend. And 3. The person is not receiving any fee, directly or indirectly. An agent also has to demonstrate that he is capable enough to represent the consumer before the consumer forum. Every agent or representative has to also adhere the code of conduct made by the regulation, including the uniforms and the manner in which he can represent the consumers. Dear friends, whether agent can seek fees? Yes, even agent can seek fees from the consumers. The Regulation 5 gives powers to the agent to claim the fees, but for that he has to make an application before the consumer forum in order to decide the quantum of the fees, and on the basis of his capabilities or the knowledge or the time spent by him, the president of the concerned consumer forum can award him the fees. Any person who is not registered as an advocate under the Advocates Act 1961 and is not debarred from practicing by way of penalty may apply for accreditation as an agent to the concerned consumer commission. An agent seeking accreditation will have to make an application in a prescribed form stating his specialties or stating in which field he will be practicing in the consumer forums. Dear friends, you will be surprised to know that there is an examination for the appointment of the agent, and the district commission is empowered to conduct a written test in order to appoint the agent so as to test his knowledge about the consumer law. The Consumer Protection Council can conduct the written test of such applicants and test the knowledge. The written test shall carry 100 marks, and those who secure more than 45% of the total marks are eligible for the oral interview. The accreditation committee may invite applicants for oral interview and then assess their knowledge. Usually, a person has to have a knowledge of the Consumer Protection Act, Evidence Act and the civil law. At the same time, a person can be appointed as an agent to practice in a particular subject like medical negligence, for which there is a necessity of having the knowledge of medicine as well as the surgery. Consumer is bound by the actions of the agent. An agent is responsible for the loss or win of the consumer in the consumer forums, and he is not allowed to withdraw the petition unless a written consent is produced by him from the consumer. The president of the concerned consumer fora has the disciplinary powers by which a disciplinary action can also be initiated against the agent. An agent can be debarred permanently or temporarily to practice in consumer forums. If the complaint is so received, the complaint can be investigated and disciplinary action can be taken against the agent. Where an agent or non-advocate is debarred by the consumer fora, then his name shall be removed from the registered accreditation and he will be blacklisted from appearing into that consumer forum. Dear friends, there is also a code of conduct for such non-advocates and agents who will be representing their respective clients in consumer forums. An agent or non-advocate shall appear before the consumer forum in moderate dress and shall make submissions in such manner so as to maintain a proper decorum of the commission. He will also not charge excessive fee from any of the clients, and the fees will be decided by the president of such consumer forums. An agent or non-advocate will not indulge in illegal activities or will not also fabricate any document or evidence. So dear friends, it is quite clear that consumer can himself go into the consumer forum and fight for himself, or even he can give his case to the agent or representative or non-advocate person. I hope you have received valuable information today. If you have liked this video, please share it with your friends and relatives, and please join my channel, Courtroom Battles. Thank you so much. Jai Hind.